Well, thank you very much for turning out to face this formidable committee. But our task this morning is to look at the implications of various outcomes of BrExit on the maritime and ports sectors. We have at 11 o'clock, we've got a number of representatives of those sectors speaking to us, but we thought it would be helpful to have somebody who was slightly more overview of the institutional and regulatory structure of the maritime sector worldwide, which is why we've asked you to explain it to us, because we have been somewhat confused at various points about which regulations apply where. So can you, perhaps open up by perhaps introducing yourselves, but then go on to explain the various interactions between the global bodies, the IMO in particular, OECD, EU, and domestic rules on the maritime side, and cover the ports in that if you can as well. Who wants to kick off?
I can start, I guess, on that one. My name's Emily Reid. I'm a Professor of International Economic Law and Sustainable Development at the Law School at the University of Southampton. And I have to say that my expertise lies essentially in international trade regulation, including the EU internal market, EU external trade relations, and WTO rules. And therefore, so I wouldn't call myself a substantive shipping lawyer, as it were. But for today's purposes, my focus really is on the implications of Brexit, therefore, for maritime trade, in particular pertaining to market access, the implications of regulatory divergence and convergence, as well as the relationship, as you just asked, really between different levels of regulation, the international regulation, EU regulation, and domestic. And I think just before I carry on with that, it would make sense for Dr. Zhang to introduce herself.
Good morning. My name is Dr. Zhang. I'm also the lecturer in School of Law, University of Southampton. I'm also the member of Southampton Institute of Maritime Law, which you see I'm part of the Brexit and Shipping Report, which you probably already get access to it. Yeah, and my specialized area is commercial maritime law, so with a particular focus on international self-goods, on shipment terms, and also carriage of goods by sea, as well as marine transport documents, such as bill of lading and relevant legal issues. Thank you.
Okay, thanks very much. Okay. Now can you unravel the whole institutional structure for us?
I would love to unravel the whole institutional structure. It's not a straightforward structure. I mean, I think that one of the things that adds to the complexity here is that we think of the maritime sector, the maritime industry, as being one sector. We think of it as an industry in itself, but in fact, it is a distinct sector, but it's comprised of service provision, it's comprised of freight transport, passenger transport. As such, it involves the free movement of goods, it involves freedom of provision of services, or certainly it requires provision of services. It engages free movement of persons. The smooth operation of the maritime sector is predicated on essentially market access, which is reliant upon regulatory convergence and reciprocity, and equivalence, if not regulatory harmonisation. So you've got a whole scheme of different issues and elements coming together, and the regulation of all of these coming together within the maritime sector as one entity that we tend to think of. The maritime industry is hugely significant in terms of its contribution to economic growth and prosperity, both within the UK and also within the EU more broadly, and again on an international scale. So it's a sector that, it has its complexity, but it certainly can't be ignored, and we have to nourish and protect it, as it were, without being protectionist. But then the other aspect which adds to the complexity, which is the one you've alluded to, is the fact that maritime transport's largely international in nature, and therefore it's governed essentially, as a starting point, it's governed by international agreement. Increasingly, however, within the EU context, there is a significant body of EU regulation, a large amount of which incorporates that international regulation and gives it teeth, as it were, and binding force that it wouldn't otherwise have. But one of the particular focuses within the EU is port regulation, And increasingly, that requires ships to comply with local regulation as well as to comply with the regulation of their flag state. So again, you've got the combination of national regulation and other regulation coming together. And obviously the extent of EU maritime transport regulation and liberalisation is of huge operational significance because apart from anything else within the EU context, the liberalisation that we have secures market access, which is what allows the maritime transport sector to operate smoothly. So, reining that back, looking at the interaction and role, the interaction between domestic EU and international law in the UK's maritime sector, we can start with the international law because that's the overarching framework. And so, in terms of international law, traditionally we have what's known as customary international law, and that's the law that states follow because it's custom and practice, but essentially an essential component of that is that states follow that custom and practice because they believe that they're bound to follow that custom and practice. So they don't just do it because they do it, but they see it as being an obligation. So that's customary international law. And that a significant body of customary international law has been incorporated into international convention. So, for instance, the UN Convention of the Law of the Sea and the treaties and agreements of the International Maritime Organization, the IMO. And some has also been incorporated into EU law. What the impact of incorporation into treaty does is it gives, I suppose, a binding force or a potentially more binding force dependent on the nature of the treaty. It can give greater teeth. So UNCLOS binds states that have signed up to and are parties to that particular agreement. Customary international law is binding upon all states. Treaty law is binding upon the states which are party to those treaties. Okay? Now, one of the challenges for international law is, although it may be binding, it frequently doesn't have great regulatory or great binding enforcement potential. Some treaties have exceptions to that. For instance, World Trade Organization law has a very sophisticated system of dispute resolution and enforcement mechanisms. But largely international treaties don't have that kind of sophisticated dispute settlement and enforcement mechanism, although there is, in the context of UNCLOS, the Treaty on the Law of the Sea. Right? The IMO has incorporated a significant body of customary international law and developed international agreements which significant number of states are signed up to, and those are binding upon those states. But one of the challenges for the IMO is with securing compliance. Then within the UK context, we also have EU law, clearly within the EU context as a whole. Now, the European Union has taken a significant volume of the IMO conventions and incorporated those into EU law. The effect of that is that EU law is dependent, assuming it meets the conditions, it will be subject to direct effect, which means that unlike international law, which is binding upon the states that are parties to it, or customary international law, which is binding upon states, EU law also creates obligations and rights which are enforceable by individuals. So where EU law has taken the IMO conventions and incorporated them into EU regulation, then those regulations can be enforced directly by individuals, including private parties, within the national courts. So in a sense, the IMO is content that the European Union has chosen to incorporate significant bodies of IMO regulation because it gives it greater binding force. And it can be used within the national domestic context. For private parties, EU law has the benefit, and incorporation into EU law and incorporation into domestic law has the benefit that it creates rights that they can enforce, as compared with the international conventions, which might be intended to create benefits for private parties, but those benefits aren't enforceable by private parties. They're reliant on states to do it. Okay, so that's the kind of three different levels. Obviously, also the UK has taken tranches of international law and incorporated it directly into national law to make that enforceable in the domestic courts.
No doubt come back to some of that, but perhaps we could hear from Dr. Zhang.
Yeah.
Yeah. So my perspective is more from the general maritime sector, which maritime sector actually can be divided into what we call the dry shipping sector or wet shipping sector. So dry shipping is more linked with the commercial shipping contracts, which include international self-goods on ship and term contracts, carriage of goods contracts, marine insurance contracts, and we will be quite relieved to know all these contracts actually not be largely affected by Brexit, because most of this contractual regime will be built on either by domestic law. So, for example, we have the UK Self-Goods Act 1979, and then we just will applicable law as English law, and we haven't joined any international convention for this area. Or we have, for example, carriage goods by sea area. If we talk about the shipment of goods and carriage of goods, we have an international convention, which is Hague-Visby rules, and most of the European partners also join into this convention. So actually, we all have the equal right under the convention, and exit from EU wouldn't cause any trouble from this level. So from commercial contracts and include marine insurance contracts is not a big problem, but there will be a few problems which I will mention later on when we talk about commercial contracts. But from the dry shipping perspective, seems not cause a dramatic issue, but from wet shipping contracts, so like a wet shipping, for example, oil pollution, shipping regulation management, and also the health safety perspective, which we have largely by EU regulation, and also which is incorporated from IMO international conventions as well. So that will anchor back to what Emily said. So we, most of the time at the moment, which the media all focus is really about the wet shipping part, about the EU regulation, what we're going to the impact of Brexit, but actually the dry shipping part is the driving force, because that is linked with international trade. But at the moment, that hasn't got enough attention, but luckily we don't have too many troubles there. We only have a few. Okay. Thank you.
Pursuing that, Lord Durham.
Yeah, I think building on what you've just said, and to a certain extent, you have answered the question, but what I'd like to tease out slightly is the key implications of if there were to be no deal. And from what you're saying there, Dr. Zhang. In fact, legally, there are few implications because these are international agreements. And the DFT rather agrees with it, said that maritime sector is a generally liberalised sector, which means that international journeys between the UK and EU can continue after exit even under a no-deal scenario, I think, which you'd agree with. There's one particular issue, though, which concerns a lot of people, which is one of the risks is the recognition of seafarer certificates of competency. Now, it seems to me that there's an awful lot of seafarers who aren't based in the UK who manage to trade perfectly well. Could you just say, are there further implications if we were to leave without a deal that you can see that would be a problem?
So for the seafarer point of view, which basically we need, so we have the training for the seafarers, and we need the recognition from the EU point of view.
Which is currently recognised.
Yes, currently recognised, and also will be recognised in a short period of time because we have the EU withdrawal bill and to return the part of the EU regulation at the moment. But obviously for future after the transitional period, and we're not sure whether this will be recognised. So, but it's not really we can solve by ourselves because it's more of the reciprocal issue as well. So it need to by negotiation with the EU parties, and then they can get recognition of the EU seafarer training and certification.
Would the EU already have joint recognition with, I don't know, the Philippines or wherever it might be, and the US?
Sorry, I'm not aware of this.
Okay.
Yeah, because the seafarer issue is more of the wet shipping issue, which I talk about. So it's more of the regulation part, but my expertise is more of the commercial maritime. But picking up, if you're interested in knowing the implication of the Brexit on this commercial maritime part, basically the huge concern is about delay.
But
it's about delay.
Okay.
So it's about delay of delivery of the goods, and also the customer union, and also the cost for the goods.
Yeah, I mean, I think, Lord Chairman, if I may, I would tend to hesitate before accepting the premise that no deal would have relatively limited implications, because I think that while a significant body of the relevant regulation is currently part of our domestic law or derived from international obligations. I think the operational implications, if we cease to be members of the European Union without a deal, are such that our access to the market would be considerably more complicated, and the impact of compliance with the regulatory requirements and demonstrable compliance with regulatory requirements, the impact of customs checks, which would become essential, then that would have significant operational impacts. So I think that if we look at it as the whole part, the key element with EU maritime regulation is that it ensures the EU principles of free movement, including liberalisation of services, and ensures that that applies to the maritime sector and also ensures compliance with competition rules, but that obviously allows us currently to benefit from equal competition within the European Union as regards the provision of maritime services. So I think that, I would hesitate to say that it wouldn't have impact. I think it has quite significant implications for the maritime sector. And I think, as a personal opinion, I would say it's very difficult to overstate that. But that's a view. I think it is quite correct to recognise that the regulation, even including seafarers, a significant body of that is derived from the ILO, International Labour Organization Convention on Seafarers' Rights, and they collected and codified 50 years' worth of seafaring standards into the ILO conventions. And those are binding, but again, as I said earlier, they might be binding, but there's very little in the way of enforcement through the ILO, whereas the EU, when the EU has incorporated it, then it gives that binding effect. One consequence when we're looking at the ILO standards is that one that you've referred to around seafarers training and seafarers recruitment. And if we lose membership of the EU without a deal, then we lose any guarantees of recognition of equivalence of training, for instance, with regards to seafarers. So again, that has operational implications.
Sorry.
I'm sorry, but I take your point about that. But what about a Filipino or a Chinese or an Indian or Bangladeshi seafarer? Presume those qualifications are recognised, because I understand an awful lot of our ships are now manned by non-British people.
And there are quite significant, there's a significant market for training of seafarers within the UK in order to ensure compliance with EU standards. And one of the issues that we need to bear in mind is that obviously access to EU waters, access to EU ports requires also compliance with EU regulation and standards. And so, for instance, there are certain jurisdictions which have adopted EU training in order to ensure compliance with those standards.
So we would have to continue EU training?
Essentially, it would be in the interest of the sector to continue to maintain equivalent standards. But then the issue that Jenny has referred to is whether or not there's reciprocity and recognition of that equivalence.
This is sort of the other side of the question, and whether there are specific areas where divergence from some of the EU rules would actually be good for the UK maritime sector. We've heard a suggestion that the structure of UK ports, for example, is rather different from in Europe, where they're more liberalised, and that there might be opportunities if the burden of EU rules was lifted from them. So that's the first question, and one of the areas that's been mentioned is this ship recycling, which I have to say I know nothing about. And if we did diverge from some of those rules, would that have an impact on our access to EU markets, as Professor Reid has mentioned?
Okay, just pick on the point of yes, so we have been arguing like divergence from the current EU regulation could be there are some opportunities. And for example, a very significant example is this EU port service regulation. And because the UK port are mainly private ports, and then it's quite different status compared with EU ports, which are more of the state public ports. So therefore, it's quite actually a lot of harmful regulation under EU ports regulation, which is not very suitable for the UK ports. And in order to boost the UK trade and also to provide efficient port service, it will be argued to say it's beneficial actually divided from the EU port service regulation. And this is one example. Another one is the ship recycling example. Then the third example actually can be called as a beneficial to us is we will have the flexible tonnage tax system. So the flexible tonnage tax system, basically at the moment we can't be very flexible because it's under EU regulation, and then that's the competition rule, which is have a limited state aid at the moment. But
sorry, it's the flexible tonnage tax?
Yes, the tonnage tax for the ship.
Ownership.
Yeah. So at the moment, we charge the tonnage tax, but we have under EU regulation, which with a certain limit. But after BrExit and after the withdrawal time period, and then we arguably that the UK can have the flexible tonnage tax system, and then we can encourage of more ship registration, and also we can just give more state aid. It really depends on national priorities. But therefore, all these areas which we can look for, they provide opportunities. But these are quite limited examples I could think of so far, because all the rest of shipping regulations, if we diverted from the EU regulations, then that will have a problem. Because all the three examples we talk about is more domestic issue. So it's more built on our domestic law, and it's all limited to our own ports and our own ships, UK flagged ships. We not talk about to trading with the EU within the EU waters as well. So if we go into the EU ports or trade with EU waters, then that will be the problem step in. So we have to obey the EU regulations.
So if we did do that, it might have some advantages in terms of what happens within the UK.
Yeah.
We would still have to comply with EU regulations if we were in our relations with them. Would there be actually any negative consequences of having made these changes in the UK?
I mean, I think Jenny's highlighted that obviously we've discussed this and thought about this and given it considerable thought in terms of potential benefits of divergence. And one of the issues is that EU regulation tends to be gold-plated. So I've said that the EU regulation incorporates IMO standards and also ILO, but IMO in this instance, and particularly around, for instance, IMO, Maritime Organization environmental standards and standards relating to pollution from ships. Now, the EU gold plates that, so it imposes higher standards than the International Maritime Organization standards. If we leave the EU without a deal that constrains us in any way, then clearly we would have an option to revert to IMO standards. We would still be bound by the IMO convention requirements, but we could drop down to those standards. Now, one area in which we could do this would be around the environmental standards, but clearly we could do that. We could say, right, we will lower the standards relating to pollution from ships. That would have significant impact upon our ports and port cities. We come from Southampton. Air pollution is a huge issue that we're very aware of. It's a very live issue. So if we were to choose to drop our regulatory standards around environmental issues, clearly there are environmental costs that would come from that. The other issue is that if we're looking at ship pollution standards, then as Jenny has already alluded to, we might lower our standards to gain a competitive advantage for ships transiting internationally and arriving in proximity of the EU. But if those ships actually want to access EU ports, they would still be required to comply. So the perceived competitive advantage it would gain us actually might not materialise if the ships are travelling on. So everything comes at a cost. I mean, we could look at whether or not we could use state aids, as, again, Dr. Zhang has said. There would be an opportunity perhaps to support the shipbuilding industry, which has been in significant decline. But we would have to still ensure that we were compliant with WTO rules, particularly around anti-subsidies. So we would move from one regulatory constraint to the international and the EU anti-subsidy. The EU anti-subsidy rules are very closely aligned with WTO anti-subsidy rules, so they're not identical, they're not as specific, but there is a relationship between them. We would still be bound by those WTO requirements, assuming that our independent membership of the WTO is established, which looks as if it's moving through. I've talked about the potential to reduce standards. We could decide that we want to enhance our regulatory standards. We could make a decision to make UK shipping a beacon of good practice and show international leadership. In that sense, in the opposite direction, which obviously would come with potentially compliance costs, but would have perhaps fewer of the disadvantages of lowering the regulatory standards. So I suppose the point I'm making there is that we assume that we might look to gain a competitive advantage because actually the maritime industry is commercial, it's trade, and it's a huge contributor to the economy. So we tend to think about where we might gain competitive advantage in terms of costs. Actually, we could go the other way in terms of quality, were we to want to. And then, but obviously, any instance in which we have divergence from EU rules potentially impacts on the ability of the UK maritime services to operate within the EU.
Because if we did go for higher standards, we would potentially be turning away shipments from the EU, which would seem slightly counterintuitive.
Yeah.
Thank you very much.
Can we just go on to the contractual side, Baroness Radisson?
Thank you. You mentioned, Dr. Zhang, earlier on the issue of contracts. And if I understood you rightly, I think you said that most contracts would not be impacted by Brexit. But you have argued in a paper that there would be immediate effects on sale contracts and charter parties. And there could be issues, for example, the inability to perform contractual obligations. And you even went as far to suggest that some contracts could be terminated because Brexit could be interpreted as force majeure or the doctrine of frustration. I wonder if you could outline in some more detail, those issues. And obviously, it's a question for the two of you.
So for the contracts, basically, I think it's really focused on the performance of the contracts. So we have the contract, you have maybe a short-term contracts, which is just a one-time sale or one-time chartering the vessel from A to B. But therefore, you also have another type, which is a long-term contract, periodical shipment, or by sale by installment, or you may have a renewable contract. So after 5 years, then you renew another 5 years. And all these long-term period contracts basically have more issues there because they may deal with before Brexit or within the transitional period. And then, but after, they still carry on performing the contracts after Brexit. Obviously, once we outside the EU, then a lot of the contracts, they may put, for example, like a description of goods. If you're selling the goods, the goods, and then you're saying the goods must be from the EU origin. And obviously, then there's an arguable point whether UK will belong to EU origin or not, possibly not after the transitional period. And or, for example, you talk about performance of the charter parties, then you're saying you have freedom of navigating through the EU waters and to load or discharge the goods within any EU ports. And the party used to choose Southampton as a part of the loading or discharge port, but now they probably couldn't carry on as the practice because arguably UK ports do not belong to EU ports anymore. So it's all these terms, conditions in the contract, and then the parties need to be aware of. I wouldn't go too far to say because of one change it will lead to frustration or force majeure to terminate the contract. I think that will be quite unlikely, quite a kind of the minor chance to get to the termination circumstances, but it's certainly the parties need to be aware of it. And then also because sometimes they may argue it's impossible to perform anymore because they used to only have the supply chain which they get is within the UK products. But now because this doesn't belong to EU, therefore they couldn't perform the sale contract anymore because the supply chain simply broke. But if they argue in this way, impossible to perform, and they say Brexit was an unforeseeable event because they haven't foreseen this Brexit vote 5-10 years ago, and they carry on performing. Therefore, I say the consequence could be you see a lot of disputes to the court or to the arbitration of saying how the party carry on perform the rights obligations under sale contract or under charter party contracts. Okay. Yeah, and obviously there another point is about the jurisdiction clause and the choice of law clause. So when they touched on, because most of the shipping and trade contracts still, we are world dominantly maritime law center. Therefore, most of the contracts still in the industry, trade or shipping industry, they all apply default rule of English law as the choice of law, English court, High Court in London as the jurisdiction clause, and also London arbitration. So therefore, these clauses could be arguable as well, because then our enforcement power for the judgment is questionable after Brexit, since we will go out of the Brussels I regulation for EU recognition and enforcement of judgments within EU member states. So the English court will lose quite significant power after that, unless we get a separate negotiation for the reciprocal treatment.
Do you think that the sort of contracts, that the terms of contracts have changed in the last 2 years? Has there been sufficient preparation in the industry for what might come?
In my personal opinion, I haven't seen much preparation going on, because people seems not too aware of it, especially for small, medium business. They don't really look in details of the contract terms, and a lot of the terms they use are standard terms, which they already pre-drafted, and the latest version, like in 2003, for example, therefore they have no idea what's in the terms conditions. And I can't see any of the trade association actually think about it and start redrafting or revising any of the terms so far.
And your paper also referred to the possibility of inefficient dispute resolution.
Yes.
Could you explain that?
Yeah. So for the dispute resolution, we are applying the English law as applicable law, and then that is within the EU regulation. We have Rome 1 and Rome 2 regulation for contractual and non-contractual obligations. So within Rome 1, Rome 2, because they are EU regulations, so once Brexit, and at the moment we're still preserved by the EU withdrawal bill, but after this period of time, then arguably that UK want to think about, we need to put them into our domestic law system. It seems not too difficult for this point of view, because as long as we have a domestic legislation to recognize Rome 1, Rome 2 regulation, then that can solve the problem, because this applicable law doesn't require reciprocal treatment from the EU member states. So the EU member states will still enforce the party's contract if they choose English law. For example, if the party has a dispute and the jurisdiction point is in France, but the party already put a specific applicable law, a choice of law article saying English law is the governing law here. Therefore, the French court will still apply the English law. So this is the applicable law point. But from the jurisdiction and enforcement of judgment point of view, that is very problematic, because at the moment we have this Brussels I regulation, or they call the recast jurisdiction regulation, and this is really for the mutual recognition between the member states of the EU. So therefore, basically the idea is if one court has been chosen by the party within the EU member states, then the other court will stay away from the proceedings. So in order to avoid multiple proceedings in the different courts at the same time. And also, if one court declares the jurisdiction, then the other court will also decline the jurisdiction within the EU member states. And then the third point is, if the English court gives the judgment, and this judgment will be recognized in all the 27 member states courts as well. So you can see the power of the English court at the moment. But once we go out of the EU, and then once So actually, at the moment, after the transitional period, there will be a problem because even they put this recast jurisdiction regulation into our domestic law, it wouldn't solve the problem because they need a reciprocal treatment. So we can say all the EU jurisdiction clause will still be enforceable here, and we will still enforce any judgments from EU court. But whether EU court will treat UK court as a part of the members, they wouldn't treat UK court as a part of member states' judgment. Therefore, whether they will recognize the English judgment will be an issue. So whether they will stay away from the proceeding once the English court start the proceeding, that will be the issue. Therefore, this English law, actually, the jurisdiction and enforcement power is significantly reduced after that. And that's really concerned the trading and shipping industry for the business because they're doing this day to day. And the jurisdiction clause is one of the compulsory necessary clause, essential they put as dispute resolution. Yeah. Thank you.
Chairman.
Can I ask you about the post-Brexit scenario where you need to create a policy which is to the mutual benefit of both the EU and the UK? What do you think would be the component parts of a good deal for the maritime industry which both met the interests of the EU and met the interests of the UK? And in answering that, could you also give some indication of what relationship we should have with the European Maritime Safety Agency? A report of the European Parliament says that it would be affected by a no-deal Brexit. So that has to be, according to the European Parliament, there has to be some sort of relationship. And clearly, a seat at the table may be not sufficient. But is a seat at the table sufficient?
Okay, thanks. So in terms of post-Brexit agreement, I mean, if we're looking at what it would be essential to have within a post-Brexit agreement in the mutual interest of the EU and the UK, we have to first start off with what we would lose if we didn't have any kind of post-Brexit agreement. And obviously the sort of starting point focus is that waterborne transport has been key to the development of EU trade and to the development of EU trade both nationally, internally, within the European single market and also externally, and to its economic growth and prosperity, and the UK has been part and parcel of that. The maritime industry is a key employer and a source of revenue within the EU, including the United Kingdom. Without an agreement, one of the implications relates to cabotage, which has already been mentioned. Currently, cabotage is liberalised for EU members, so that's where you've got transport between ports within one state. Traditionally, that has been retained for ships of the state where the ports are located. Under the EU liberalisation, then cabotage has been opened up for EU members so that it can be provided by other EU nationals within the European Union. So without an agreement, that would be lost. Secondly, obviously, we've already alluded to the fact that we currently benefit from EU liberalisation of services. That would be lost without an agreement, and that includes the freedom of establishment, free movement of goods, which has impact on customs, which has impact on the operation of maritime transport and maritime trade. Thirdly, shipping is essentially about trade and essentially about services provision, so loss of the agreement relating to maritime transport would have a significant impact upon access to the market. So turning that around, what provisions would be necessary to have an effective agreement? We would be looking for provisions to guarantee market access, to secure market access. And within that, obviously, liberalisation of services, which goes hand in hand with market access in the shipping sector. You'd be looking for recognition of equivalence of regulatory standards. We've talked about that earlier, and that goes to both, standards of ships, pollution, environmental, but also seafarers' standards. And we'd be looking for equivalence of regulatory standards, particularly relating to maritime safety, security, prevention of pollution, and response to pollution caused by ships. We'd be looking for recognition of those standards, and clearly we'd also be looking for reciprocity, I think, that in order to make it work. The reason why we would want to particularly focus on maritime safety, security, prevention of pollution and response to pollution goes to your question about the European Maritime Safety Association. And looking at that, obviously, our membership of the European Maritime Safety Association would be affected if we leave the European Union, because at the moment the European Maritime Safety Association is open. The members are the member states of the European Union and the EFTA, European Free Trade Association. Given the importance of the Maritime Safety Association, particularly in the light of disasters such as that of the Erika, it would make sense that the UK seeks an agreement which would allow it to have member status. The EMSA rules of procedure allow for representatives of third countries, and I think it would be desirable that the UK would push for that status. But membership of third countries is conditional upon Article 4.2 of the relevant regulation, which states that representatives of third countries, having entered into agreements with the European Community in accordance with Article 17 of the regulation, are entitled to attend BORS meetings under the terms and conditions specified in the agreements. So clearly, we'd be looking for an agreement between ourselves and the European Union which would allow for, which would give provisions, because Article 17 then refers to agreements which have adopted and are applying community law in the field of maritime safety, security, pollution and response to pollution caused by ships. Hence the need to make sure that that's contained within an agreement. If we have that contained within an agreement, then we would satisfy the preconditions to push for representation status at the European Maritime Safety Association, because we wouldn't, I think, want to be relegated to observer status in the event of particular agenda items of interest, which would be the alternative. But that's possible within the rules of procedure of the EMSA. It's just the obvious challenge is to get the agreement between the UK and the European Union to satisfy those conditions for status, for member or representation status. But I think it would make sense to have that.
And do you get any sense that the UK government is actually dwelling upon these matters at the present time and thinking them through?
I don't think I'm best placed to answer on that. I know what the conditions are, but I mean, as I've said at the outset, my expertise is more with the trade side, and I can't say whether or not the UK government, I think you, as a committee, you might be better placed than me. But I'm certainly willing to highlight the need for that to be considered and recognised.
Could I just add one question to you then about something which Dr. Chan said about basically state aid and mutual recognition of qualifications? Those are two issues which have been raised with us as a committee in other dimensions as well. How significant do you think both of those matters are likely to be, given that any agreement we assume with the European Union will require some obligation, as it would with the WTO, on state aid or subsidies? How significant would you think that's part of any post-Brexit agreement that we need to have?
I think recognition of qualifications is something that we would want to have, because that's part and parcel of it's essential to facilitate the free movement of persons and freedom of establishment. And so if we're looking to secure facilitation of maritime trade with the EU after Brexit, then we would want to be securing that freedom. You know, it's part and parcel of access to the market. So we would need recognition of qualifications in order to facilitate that. It's all very well to have a right to take up employment or to provide a service, but if your qualification isn't going to be recognised, then you don't actually have a right that you can effectively enjoy. With regard to state aids, the issue is that, yes, absolutely, under EU law, we are very constrained with regard to state aids, particularly towards, for instance, the shipbuilding industry. We would want to consider how that would be taken forward. But obviously, as we've already recognised, there are WTO rules with regard to subsidies and what's legitimate and what's not, that we would have to ensure that, or we would still be constrained by, regardless of what we might agree with the EU, we would still be constrained by those WTO subsidies rules.
Okay, thank you. Thank you, Joe.
Thank you.
You have indicated that currently EU companies may fly the UK flag even if they're not resident in the UK, provided they're represented by a UK resident or an EU company with a place of business in the UK. And you have concluded that after we leave the EU, the UK flag should continue to be recognised as an EU flag for fiscal and environmental purposes. So would you elaborate for us what the implications are for existing and future registration interests with the UK flag?
Yeah. Okay.
Do you want to say that?
Yeah. So basically, at the moment, because the UK ship registry under UK flag is regulated by Merchant Shipping Act, which is our domestic law, and also the Merchant Shipping Regulation of Ships Regulation, which is our domestic regulation. So it's identified that we can register the ship owned by a qualifying owners. So the qualifying owners is being identified under the EU regulation, which will be approved at the moment. So under EU regulation, the qualified owners will include the EU member states and also EEA nationals and bodies, as well as the European Economic Interest Groups, which this group is under the recognition by the EU law, by EU regulation. So then the problem for us is wider after Brexit, that we want continuing to recognize the EU or EEA nationals that will continue to be the qualifying owners under our domestic act. So basically, then the UK has a say on it to say we want to remove all these legal identities of these parties, and then we just want to be the the UK qualified owners only. And then you can also open up to say even we welcome to all the qualifying owners from all the world, international. So I think that will depend on our national priority of the economic benefit, and also depends on the citizen status that we negotiate with EU, as well as that the reciprocal matter to see how the EU will open up to the UK ship register as well. So there is existing, at the moment, we recognize all the EU or EEA nationals and bodies to register UK flag, but we can't cut this off by removing them in the future. And once we remove them, then these people, they will be eligible, and then their ship at the moment registered under UK flag could be terminated. And then once they terminated, the next step obviously is quite uncertain, but from the previous evidence, the next step, if they don't have any British connections, they can force to sell the ship by the English court. So that will be for the existing ones. For the future ones, once we stop to register to qualify these EU or EEA nationals, then they can't register the UK flags anymore. But as I say, it really depends which way that UK as a shipping industry's interest and benefit wants to go. Okay, thank you. And also one point I want to just supplement is about the impact of the free movement of the ship registry, because at the moment that under the EU regulation that is within the EU states that the ships, they can change or switch the registry within EU, and it doesn't have extra documentary requirement. It only have the basics. So it's saying we can't impose extra requirement on ship registration. But after Brexit, which is after the transitional period, obviously we can just hire the requirement about how to switch. It also has the problem of then the EU ship will feel very concerned if they currently register under UK, then they wouldn't be allowed to switch back to any other EU flags. So therefore now seeing the rush of the people registered under UK flag will all move back to EU. Therefore, they got 27 member states to switch the registry. But they obviously pose a problem for the UK flag at the moment.
Can I just ask, what's the worst case scenario, and what would be the economic implications of that worst case scenario?
I think the implication for economic will be the cost. Because if we, as the UK flag is quite well recognized because we have a very solid regulations and also the good standard to maintain the ship as well. But once we're decreasing the fleet, and then that will have a kind of let's say in this international ship registration class, the industry. as well as then the tax problem as well. So we probably have a quite a significant reduced revenue on that.
Okay. We're coming towards the end of our time. I've got one question from Lord Russell here.
Very quickly. So, in September last year, the Transport Secretary, Chris Grayling, made an announcement that the government would deliver a strategy to foster the growth of the maritime sector post-Brexit and to launch, quote, a British shipbuilding renaissance, and that to that end the government would consult widely to build that strategy, assuming that he was intelligent enough to ask you for your view on what the components of that strategy should be. What would your advice be?
Sorry, can I just clarify the question? Is that how to boost the UK maritime sector? Or?
Yes,
Yeah.
the implication is that post-Brexit there will be enormous opportunities, and the idea is to build a strategy which identifies, takes advantage of, and actually has an implementation plan to realise those opportunities.
Shall I? Yeah. So just actually just a very quick point about we should maintain our standard, our leading status of being a maritime law centre, the World Maritime Law Centre, because that also linked with the financial service as well as the trade service and our economic growth as well. And this point we need to absolutely recognise, apart from London jurisdiction, the English court jurisdiction, English law, we also have London arbitration. And this is the point we absolutely need to boost, because nearly every single shipping commercial contracts, we have London arbitration. And obviously at this very vulnerable moment, you can see other part of the world also want to take the lead on that and shifting the legal centre to the east. But UK want to absolutely maintain this because we already have this centre even before the European Union. Therefore, why not? We can't keep it.
Thank you.
Thank you.
Sorry, is that the Baltic Exchange? Or not?
Yeah, I mean, it's part of the legal service, but we also have London arbitration. Yeah.
So in terms of strategy, I mean, clearly, as we've said throughout, the maritime sector is inherently international, and whatever the strategy, whatever form it takes, what it would have to do is secure continued liberalisation. So the strategy post-Brexit, if it didn't allow for continued market access with our largest trading partner as it currently stands, the strategy would face considerable challenges. So I think that, we would need to pull out all the stops to secure that market access and continued, therefore, regulatory equivalence and reciprocity with the European Union, because otherwise it puts a considerable obstacle in the place of the kind of renaissance of the shipping trade within the United Kingdom. Obviously, we've talked a little bit about the potential for support for the shipbuilding industry, taking that as an opportunity. Clearly, that's not going to be possible if we're required to comply with EU state aids within that kind of market access package, and the competition rules are part and parcel of market access. But equally, we've also recognised that any kind of support to the maritime industry and sector, whether shipbuilding or other bits of it, would have to be compliant with WTO regulations and other international regulation. So in terms of opportunities for the maritime sector, I mean, I think, as Jenny's already alluded to, you've got the opportunity to re-establish leadership in the maritime sector. But there are two different ways of doing it. One of those ways is going for a deregulation, slide to the deregulatory approach to increase people coming in or entities coming into the sector. We could choose to look at the ship register, and there has been a suggestion of looking at opening up the potential for access to the UK ship register in order to not only allow EU and EEA nationals to register, but open that up much more broadly in order to increase the size of the UK fleet. However, what we have to do is ensure that while doing that, we don't become less attractive And obviously the risk of any kind of deregulation is that we do become less attractive. So in terms of opportunities and strategy, we would ideally be looking at ways of leading the way internationally. So that kind of returning to the UK as a leader in the international maritime sector, and leadership within, for instance, the IMO would be a possibility, because currently when we are engaged in the IMO, obviously the United Kingdom is a member of the International Maritime Organisation, but it is bound by European Union common positions. Although the EU is not a member of the IMO, all the member states are, and they act as a bloc. Once we're no longer part of the EU, there is the opportunity opened up for leadership and a more independent stance within the IMO. But obviously we would have to think carefully about how we want to use that leadership, or what direction we would want to take it in. In an ideal world, you would be looking at enhancing standards for all engaged in the maritime sector. That's enough.
Well, thanks. A quick question from Lord Weekly and a quick one from me, but can we keep it short?
Brief one. I don't want you to expand unduly on it, but indicate the direction. You've spoken from a general UK context. Does that equally apply to Gibraltar?
Which particular aspects?
Well, are there any aspects of your answers that you believe don't apply to Gibraltar?
I would have to reflect on that. Yeah. Sorry.
Okay.
But I'm quite happy to come back to you on that.
Yeah, okay, thanks.
If you can find the answer to that, can you write into it? Two very quick points from me. One, right at the beginning you were talking about enforcement of regulations, most of which subsequently you talked about through the British courts. Is there any enforcement mechanism in this area that we would have to reinvent outside the EU, because hitherto it has been European institutions or global institutions which have been part of the enforcement mechanism? In other fields we find, for example in the environmental field generally, we find there is a need to establish a new institution. Michael Gove's working hard at that, so I'm told. But what about in this area?
Well, in terms of the fact that the vast bulk of, for instance, in terms of getting enforcement of the international regulation, a large part of that is done currently through incorporation into the EU regulation, which therefore gives effect within the UK domestic context and can be enforced within the UK domestic context. As to the extent that the EU acquis are translated, incorporated into UK domestic law, that would be secure. The question would arise once we move away from that and start to diverge, but then presumably in moving away and starting to diverge, we would be creating new laws which would be capable of enforcement. The other side of that would be if there are international norms which currently have binding effect upon us through the EU regulation, if there are new international norms or treaties agreed to that we didn't incorporate directly ourselves, then there wouldn't be a binding enforcement mechanism necessarily by virtue of them as part of the international agreement. So
okay.
Do I need to turn that around?
My other point very quickly is that the dominance of British practice across the maritime industry reflects back when all these League of Nations and the United Nations bodies were set up. We were the dominant fleet. We were also the dominant shipbuilding sector, incidentally. But that is no longer the case. Will all that legal expertise, contractual expertise, insurance expertise, etc., that has reflected our one-time dominance in this market, would it suffer if we came out of the EU, or could it be maintained, in your view? I'm particularly thinking of the legal and insurance side.
I think for the insurance point, that had a bit of issue because this is passporting right. So insurance company, they feel worried, especially like, for example, lawyers. They feel very worried that they wouldn't have passporting right of providing service in the EU. Therefore, they just open a branch in Brussels and then trying to secure that they have both in London and in EU as well. So they have a lot of argument about whether they can still continue providing service after BrExit. But from the legal point of view, for the contracts and for the commercial practice, this has been always the case that the British English law is the dominant law, and then also the convention and also the domestic law has been copied to other states as well, to other countries. So I don't think that will lose the impact.
Okay. Right, thank you very much. It's really interesting. In a lot of these sectors, we find the sector itself may be a bit vulnerable, but the lawyers are doing quite well. So, thank you very much for your expertise. And we'll move on to our other witnesses now. You're happy if you stay, and if there's anything else that occurs to you, can you write it into the Secretariat here? Thank you.
Thank you very much.
Thank you.
Could our other